We are waiting for a few more minutes. I will start the PowerPoint presentation and then we can go ahead. Welcome everyone to this hybrid seminar on access to housing. This seminar is one of 3 sessions. I'll talk a little bit more about that later. But first of all, I will briefly explain again what the EVICT project actually is about. And of course, it's about the right to housing. We're not only focusing on eviction, so not only on exit rights, but we try to study the whole network of the right to housing. And if we take a look at what that actually looks like, this is what we already know about the right to housing. There are a lot of international treaties, instruments, bodies, documents that refer to the right to housing. And as of course we all know is that the right to housing doesn't only deal with the right of a roof above your head. It deals with security of tenure, it deals with accessibility, cultural adequacy, affordability, habitability, availability, and location. And it's laid down in a lot of international and regional instruments, and of course also in a lot of national constitutions. But this is what we already knew. What the EVICT project tries to do and tries to study, whether it's not only a spider, but is the right to housing actually also a network? So do these international documents and international treaties, committees and bodies, do they interact with each other? And how often do they interact with each other? In what way? And could we visualize that? And could we try to calculate network statistics? And that is where the EVICT project comes in. We try to combine legal research with data science to develop the right to housing, the network of the right to housing, and the concept of the right to housing. And in this hybrid series, we focus on a typology of the right to housing. Within the EVICT project, we really believe that there are 3 types of right to housing. We have access rights. So what kind of rights do people have when looking for housing, when accessing a house or trying to access a house? What rights do you have if you're already living in a house? So quality of living, for example, and living standards. And what rights do you have if you're forced to leave the house? And these 3 typologies of the right to housing will be central in our hybrid seminars. So this is the first one on access rights. And then we have a second one in a few months on in-housing rights. We have a third and a last one on exit rights. And this is the first one of the series on access rights. This is the program of the seminar. We have 3 speakers, Dr. Roxani Fragkou, who is sitting next to me, Stefan van Tongeren, he's a PhD student here at the Faculty of Law, and we have a new colleague within the EVICT project, Andrei Quintiá Pastrana, freshly arrived from Spain, but now located and based in Groningen. And each of the speakers will address difficulties and obstacles, but also the importance of accessing a right to housing or accessing a house. And Dr. Fragkou, she will do that for asylum seekers, and Stefan van Tongeren, he will do that for ex-offenders, both groups within society facing a lot of obstacles with accessing a house. And Andrei Quintiá Pastrana, he will do that for more generally the administrative process and the digitalization of that process, and how that creates obstacles for accessing housing. And after all 3 presenters, we will have a discussion between the speakers for about 10 or 15 minutes, and we open the discussion up for the public, for you guys. We have 2 student assistants who monitor the chat. We hope that you want to join the debate or the discussion lively by using your microphone, but if you're somehow not able to do that, you can post a question in the chat, and Maria and Emma, who are available here, they will monitor the chat and they will break in and open up the discussion with your contribution. But without further ado, I would like to give the floor to Dr. Fragkou.
Hello everyone. Thank you very much for this opportunity to have this discussion today. I'm really happy to be with you. So together we are discussing access.
That's a little bit slow.
Yeah, thanks. So together we will be discussing access to housing for asylum seekers and beneficiaries of international protection in the EU. So people on the move, whether they are refugees, asylum seekers, or internally displaced persons or migrants, they're particularly vulnerable to human rights violations, including of the right to housing. Many of the EU member states, actually, despite their obligation under EU and international human rights law, they fail to implement the right to access adequate accommodation vis-à-vis a considerable number of people in need of protection. Why? Well, the most obvious, I'm sorry, I think I should go behind. Yeah. Why? Yeah. The most obvious reason has to do, apparently, with numbers. Yeah, that's the right slide. The number of displaced people around the world, and of course the number of people seeking asylum in the EU. Actually, the EU member states have received, as you can see, in 2021, more than 632 applications for international protection. Throughout my presentation today, I will use 2 examples, the Netherlands and Greece, both countries having experienced an increase in applications for international protection, and both countries having demonstrated low levels of preparedness to deal with it. Greece was fully prepared back in 2015 when it actually received an influx of migrants and refugees, while the Netherlands is currently facing such a challenging situation, while both countries received more or less the same amount of applications in 2021. So what will be my focus today? I'll try to highlight the challenges asylum seekers and refugees face in accessing decent housing conditions in the EU. Well, all of the pictures you will see in presentations are from EU reception centers, either in Greece, both the islands for the mainland, or in the Netherlands, mainly it's the Terapel reception center. And I guess I had to clarify this because of really the strength of the images. Well, undoubtedly, human rights are as universal rights of every person, irrespective of race, color, gender, disability, age, sexual orientation, or gender identity. And as such, the right to adequate housing are guaranteed at national, European, and international level in several legally binding or soft law human rights standards. The point I'll try to make here, though, is that the unconditional recognition of a right seems to be inadequate when it is subject, when its full implementation is subjected to a variety of diverse circumstances, including the financial situation of the country or the political will of policy or lawmakers. To demonstrate this discrepancy between law and practice, between the rule and its implementation, I would have to describe the legal framework regarding the right to housing and then examine whether law is observed effectively when it comes really to the most vulnerable. Well, I will not do that because I really have less than 15 minutes left. And besides, Bruijn mentioned most of this in her opening. I will confine myself to mentioning that the legal framework of the right to housing contains a variety of legal instruments at international, regional, and EU level. In this slide, actually, you can see the main provisions of human rights standards where protection of the right to housing intersects with protection of refugees and asylum seekers. But I won't bother you with these details in my presentation. Most of it is well known, actually, so that I can move on to the main part of my talk. So, if human rights are regarding access to housing for refugees and asylum seekers seem to be adequate, the main question arising here, inevitably, is whether law is actually effectively observed when it comes to the most vulnerable. And as we will see, in most cases, the answer is no. There is clear discrepancy between law and practice, between rule and its implementation. And this is confirmed by several international, European, and national monitoring human rights. I should probably clarify further on who we'll be talking about, as for purposes of economy of time, I will not refer to all types of mixed migration. So I will only focus today on those seeking international protection, meaning refugee status and subsidiary protection status, as well as the beneficiaries of this protection. So who is a refugee? Refugee is a person who has fled his own country because he or she is at risk of serious human rights violations and persecution due to 5 reasons: race, religion, nationality, social membership in a social group, and political opinion. A beneficiary of subsidiary protection is a person who has fled his or her own country due to different reasons than those 5 mentioned before, such as violence or war. This person does not actually qualify as a refugee, but he or she would face a real risk of suffering serious harm if he would return to his country of origin. And an asylum seeker is a person who has left his own country for some of the above reasons, seeking international protection, but hasn't been yet legally recognized as beneficiary of this protection. Let's now move on to the heart of today's debate, which inevitably relates to reception conditions. Well, reception conditions vary from one EU member state to another, and it's true that there are a lot of differences, really important differences, one EU member to the other, with the accommodation conditions in many EU reception centers being far from complying with the EU standards. Well, for instance, back in 2015, during the huge refugee crisis in Europe, the reception centers in Greece were not adequate to welcome all those thousands of refugees entering the Greek territory. And therefore, although the state is and should always be responsible for accommodating and receiving those people, the Greek state in 2015 delegated the reception to NGOs. Well, this, of course, is not acceptable, and quite later, actually, very recently, it was even confirmed by a very important Greek court ruling, which recognizes the state's tort liability for its failure to provide proper reception conditions to asylum seekers and to refugees. More specifically, the court made clear that living in a temporary tent with absolutely no access to basic services and necessary infrastructure violates national and European legislation. Let's see, now let's focus on the 2 examples we are studying today, the Netherlands and Greece, where state authorities in both countries are actually facing challenging situation with regard to the right of housing of asylum seekers and refugees. Well, let's first see under which conditions an asylum seeker or a beneficiary of international protection may have access to housing in the Netherlands. Asylum seekers must report to the Immigration and Naturalization Service at Terapel. After identification and registration of their claim, they are transferred to a reception center where they are allowed to stay until they are granted international protection, and the Central Agency for the Reception of Asylum Seekers, the COA, has arranged housing facilities in cooperation with municipalities. Well, in theory, because in practice, due to the housing crisis brewing in the Netherlands, recognized refugees live in reception centers for longer than what they should. In fact, on January 1st of 2022, there were about 12,000 recognized refugees residing in COA reception centers. To this end, the Dutch authorities have introduced two additional schemes, the hosting scheme and the hotel and accommodation arrangement. Well, according to the hosting scheme, recognized refugees can stay with family and friends awaiting their house for up to 3 months. And the COA agency gives an additional payment of 75 euros per week to refugees aged over 21 years old to encourage them actually to access this. According to the second one, the hotel and accommodation arrangement, temporary accommodation might be also provided by a hotel or an Airbnb for up to 6 months. But after that time, the municipality has to have found accommodation for those people. From September 2021, the Netherlands started facing a reception crisis, partly due to the COVID-19 pandemic, as well as due to the generalized shortage of houses for rent in the country. By the end of 2021, a total of 34,000 people were actually accommodated by COA, which amounts to 8,500 people more than the previous year. This had, as a result, people sleeping on the floor outside the first reception center of Terra-Bell, waiting their turn to register their application. Well, MSF, Doctors Without Borders, who deployed a team providing basic healthcare to those staying at the Terra-Bell, compared the situation in the Terra-Bell reception center to the living conditions at the Moria refugee camp in Greece, which up to date is probably considered the worst refugee camp in Europe. These conditions were actually highly criticized by the Council of Europe Commissioner for Human Rights, Dunja Mijatovic, who pointed out that the current situation for refugees and asylum seekers in the Netherlands appears fall short of even the minimum standards under Article 3 of the European Convention of Human Rights, as it was also criticized by a more recent Dutch court decision dated 6 October, where the District Court of The Hague actually ruled that urged the Dutch government to bring conditions in Dutch emergency asylum centers up to EU standards. But what the court said is that refugees are entitled to at least 4 square meters of space, a door that can be locked, and a window that can be opened, as well as sufficient food, drinking water, and clean sanitation. Well, basically, a roof over their head to guarantee all that, safeguard all this. In fact, the province of Groningen, which is home to the Terra-Bell Reception Center, has provided more accommodation than most municipalities. In total, 194 of the 345 local authority areas have not made any accommodation available. Legislation is expected in January 2023, which would eventually allow the Dutch government to force local authorities to accept refugee under a quota system. As for Greece, accommodation facilities, IDOMES, as we call them, offer temporary accommodation to asylum seekers, their family members, minors, either they are accompanied or unaccompanied, and vulnerable individuals. Well, in the case of Greece, recognized refugees have to leave the premises within 30 days from the moment of the granting of international protection. Therefore, they can no longer stay in reception centers as it happens in the Netherlands. However, unaccompanied minors may remain residents of the facilities until they become adults. Despite considerable progress, Greece continues to fail to meet the criteria with regard to the right to housing of asylum seekers. as it has been highlighted by several human rights monitoring bodies since 2011, including by the European Court of Human Rights. I'm referring to the famous MSS case against Greece and Belgium. Well, the new trend seems to be the closed controlled access centers. 1 year after the inauguration of the first such center in Greece, Samos, 2 more are actually being operational today on Leros coast, 2 more islands, and 2 additional closed controlled access centers are actually being built right now on 2 more Greek islands. Concerns were actually raised from the outset of this initiative that residents would be subjected to disproportionate control and restrictions on their movement into surveillance methods which are more associated to prison-type controls than to facilities actually who are supposed to host and support people seeking for international action. This being said, I could not close today's presentation without mentioning an acknowledged best practice, the ISTIA program, which stands for Emergency Support to Integration and Accommodation. It was initiated in 2015 in Greece by UNHCR, and it came to offer accommodation through apartments as an alternative solution to accommodation, actually, the mass accommodation in camps. The ISTIA program was unique at a very, very challenging time of emergency in Greece, and it really made a difference for many people as urban locations of the apartments offered to refugees facilitated access to many services such as schools, language centers, hospitals. In addition, social workers were also assigned to specific households to support families with their stay. So to wrap up my presentation, I would have to go back to where I started to try to answer the question raised in my title. So with a focus on the principal challenges encountered, analysis of the current reception conditions, which greatly differ from one country to another, shows that really we are far from being able to speak about an adequate housing or shelter. So implementation of the right to housing is definitely not a reality when it comes to refugees and asylum seekers in the EU. It is more of a test of our humanity, of our civilization, and it determines whether democratic values are really applied. Let's hope it's not utopia either. Thank you very much.
Works. Yeah. Thank you. Thank you. Thank you very much. Also, thank you for having me, for allowing me to talk here today about the right to access during this hybrid construction, which is very interesting because I don't see any faces apart from the small ones over there. I will be discussing the right to have access to housing in light of my PhD research, focusing on the paper I'm currently finishing writing. On the slide, you can see a clip from the movie. Most of you movie lovers or blues lovers will recognize it. It's the opening scene from the movie Blues Brothers, in which Jake Blues is released from the Joliet Corrections Center in Illinois. Now, those of you who have seen the movie probably remember that his brother Elwood Blues is waiting for him to pick him up in an old police car and taking him home to where they both live. Now, Jake Blues had a brother who was willing to take him in, but many released prisoners do not have this, let's call it somewhat euphemistically, luxury. For instance, in the Netherlands, about 20% of released prisoners have no stable and adequate housing they can go to. And that's what I'm focusing on in my PhD research, namely ex-offenders' problematic search for housing. Having access to housing is, as we all know, essential for persons' well-being. This is, of course, also true for the ex-offender who is trying to return into society and become once more a full and productive member of that society. And housing not only provides physical shelter against the outside world, but it is also crucial in organizing other important parts of one's life and of the ex-offender's life, such as ensuring an income or coping with addiction. And it's called the linchpin or the keystone, hence the picture, that holds the whole ex-offender's reintegration process together. However, finding adequate housing might be problematic for many offenders. You see that I put this word cloud in a house shape. Here we see a number of issues or barriers ex-offenders face when trying to find a place to live. And of course, ex-offenders face common issues such as housing shortages, which are quite general in the Western world, or digital illiteracy, which Andrei later on will talk, but also very specific problems such as substance abuse, parole stipulation, stigma, blacklisting by property owners. And one particular phenomenon affecting ex-offenders' access to housing that I will be focusing on in this presentation is social unrest. Communities' response toward the arrival or presence of an ex-offender in the neighborhood. Feelings of fear or anger may result in social unrest, which in turn may escalate into serious threats of the public order in the area. Now, every now and again, we read about cases in the media or in research reports concerning social unrest following the return of an ex-offender into the local community. And here we see some examples. So most previous studies researching this phenomenon mainly focus on returning sex offenders, as the return of those ex-offenders or ex-offenders with such a criminal history appears to give them, the most rise to concerns and anger among community residents. Here we see two examples of people protesting and warning with leaflets against a convicted pedophile apparently returning or living in the neighborhood. So the top left picture is a memorial service for an elderly Dutch man who was accused of being a pedophile and was consequently beaten to death by a group of angry people who tracked him down. And in the bottom right, you can see a picture of people protesting against the release of the murderer of the Dutch politician Pim Fortuyn. Now, of course, these are very extreme examples of escalating social unrest following the release of an ex-offender. The type of cases you hear about in the news, for instance. But a different, less extreme example of social unrest was one of the cases I had when I was teaching some students here in Groningen. One student, about 18 years old, from Romania, she came to me and she told me that she lived in a house, and next door to her, so they shared the front door, came a neighbor who told her that he had been released from prison after serving a 6-year sentence. And afterwards, she felt totally uncomfortable and unsafe in her own home. Now here's the definition of social unrest, which shows that it not only encompasses the extreme cases I just showed on the previous slides. So social unrest can be defined as the reaction of a population characterized by negative emotions and feelings, such as fear, anger, dissatisfaction, etc. And the expressions of these emotions and feelings may or may not be observable. So they may not or may not be audible, visible, or legible. Now, if we look at this, that's derived from the ministry. So if we look at this phenomenon from a, let's say, lawyery point of view, what do we actually see? Well, we see conflicting, sometimes clashing human rights, fundamental rights, including the housing rights, which this presentation will focus on. So on the one hand, we have the released ex-offender who has, like we all have, a fundamental right to have access to adequate housing, which this seminar is about. Yet on the other hand, the future neighbors of the returning ex-offenders have a right to enjoy their home and live there in safety, peace, and quiet. They have a certain rights in the home, which the next session will be about. And that can conflict with ex-offenders' access. Now, part of my PhD project is to study these conflicting housing rights and to determine how local authorities and the partner organizations aim to balance these rights, using the Netherlands as a case study. There are 3 questions I would like to briefly discuss with you as part of an exploratory study I'm currently working on. So first of all, how often does social unrest actually occurs resulting from an ex-offender returning to the neighborhood. So there have been a number of studies on this topic in the Netherlands and also outside the Netherlands, and especially the more extreme cases, as I've shown just now, receive a lot of media and political and, let's say, scholarly attention. But how big is the actual problem? Next, how does it manifest itself? So how do local authorities in the Netherlands become aware of the feelings of social unrest, the feelings of concern, anger, panic among community residents? And lastly, how do the Dutch authorities and their partner organizations aim to prevent or end this social unrest? Now, to study this, I conducted, among other things, a survey study among the 45 largest Dutch municipalities, 38 of which participated in the study. So first, a series of questions were asked concerned the frequency with which social unrest occurred in their municipality over the last 6 years, and how this social unrest unveiled itself to the authorities. Now, this provides a first quantitative assessment of the actual scope of the problem in the Netherlands. And it was revealed that roughly 2/3 of respondents recalled social unrest occurring during that studied 6-year period. 1 in 4 respondents, so about 24%, replied that they had no such experience, and only 3 respondents indicated they did not know whether something like that. Now, respondents were then asked how this social unrest manifested itself, and the table presented here on the slide shows that the arrival or presence of an ex-offender less often directly threatened the public order in the area. So over the 6-year period, 10 respondents, or about 27%, recalled social unrest existing, of threats being issued, property being destroyed, or violent behavior being displayed. Protests by neighbors, such as demonstration, the distribution of warning leaflets, as we saw in the 2 pictures on the previous slide, those were reported by only 3 respondents. So these findings shows that whereas in most major Dutch municipalities, peaceful expressions of social unrest occurred relatively frequently, let's say monthly or yearly basis, but escalations that actually threatened the public order and peace and quiet in the area are only occurred rarely, so once a few times over the 6-year period. So from these figures, it first of all becomes clear that social unrest manifests itself in more ways than the extreme examples of protesting neighbors that we just saw, and which most studies focused on. It even seems as if cases in which the public order is actually and acutely threatened by the arrival of an ex-offender are not that common. And of course, it doesn't say anything about the seriousness or the intensity of these cases, but it does show that the scope of the problem is much less significant or much less large than one perhaps expect based on the attention it receives from researchers, me included, and policymakers. Now, knowing that the great majority of these studies focus on the return of sex offenders in the neighborhood, respondents were then asked about the specific factors particularly triggering that social unrest. And 50% of the respondents indicated that it was a specific criminal background that was the reason behind it. These respondents were then asked what type of criminal offense the returning ex-offender had been convicted for. And the figures seem to justify the focus by researchers and policymakers on released sex and violent offenders. Of the 24 respondents, 11 reported that the ex-offender had a criminal history consisting of sex offenders, and 8 respondents, or 1/3 of the respondents, recalled the ex-offender also having a background of serious violent crimes. Well, we see convictions for street robbery and theft, other public order offences, such as noises, public drunkenness, arson, added by 1 respondent, were all only named once by respondents. There's 2 more tables I would like to show you. Because the respondents were also asked how they aim to prevent social unrest. Would they embrace a more, let's say, repressive approach towards the housing of ex-offenders, preventing them from settling themselves in the neighborhood? Or would they allow the ex-offender to freely settle him or herself in the neighborhood, irrespective of community residents' feelings and concerns? Or would they try to find some balance between the ex-offenders and future neighbors? Well, in the past, we've seen that Dutch local authorities would issue area exclusion orders. So basically orders to ban ex-offenders from the municipality. And Dutch courts have on multiple occasions ruled these exclusions orders unlawful. However, we also know from previous studies that these bans are still being issued. So how do local authorities aim to prevent social unrest? Well, from the survey results, it becomes clear that 87% of the respondents would enter into a sort of informal dialogue with the ex-offender in order to find a way that would ensure both the ex-offender's right to access housing, while at the same time meet the concerns of his or her future neighbors. 78% of the respondents indicated that efforts would be made to relocate the ex-offender, to try to find alternative housing elsewhere. And we asked how they would try to achieve this. About 80% of the respondents reported that the ex-offender was actually provided with alternative housing by the municipality or by a different municipality. And most respondents indicated that only if the ex-offender would not cooperate and refuse to accept the alternative housing would they issue an area exclusion ban or sometimes also close an ex-offender's home, thus preventing him from returning to the area or settling in the area. We see similar results when asking respondents about measures taken to end the already existing social unrest. Authorities would rather use more, let's say, informal, more non-repressive measures before finding it necessary to use the more repressive powers to force the ex-offender to find housing elsewhere. And interesting here is also that it's the reason for local authorities to not intervene with social unrest. So according to the respondents, one reason for not acting upon social unrest would sometimes be that this was deemed disproportionate to the nature and seriousness of the social unrest and the existing threat to the public order. But these local authorities apparently do take into account the proportionality of the measure they consider. So in cases in which the release and the return of an ex-offender into society leads to social unrest in the local communities, do local authorities in the Netherlands strike or aim to strike a balance between the competing housing rights? So the ex-offender's right to have access to housing on the one hand and the community residents' right to quiet enjoyment of their home on the other hand. Well, the figures seem to indicate that most of them do, or at least try to. Contrary to previous research, repressive measures such as area exclusion orders or house closures, home closures, do not seem to be widely used. And according to some of the respondents, they are only used in situations in which the ex-offender refuses to cooperate to accept alternative housing elsewhere. Now, of course, one should take into account that these are figures provided by the municipalities, by the local authorities themselves. And of course, that due to a lack of qualitative data, it remains unclear exactly how much effort local authorities take to prevent or end social unrest before they refer to the more repressive measures. It should also be noted that it seems as if usually it is the ex-offender who has to find another location to live in order to prevent or end the unrest. And the figures show that in very few cases, the authorities did offer alternative housing to someone else, like the victim of the offender or family of the victim of the offender. So while this might be understandable from a perspective of efficiently and effectively end existing social unrest, one could in some cases also argue that local authorities perhaps also have a duty to ensure an ex-offender's right to access to housing, even if this upsets his or her neighbors. Of course, this might be more easily said than done. So for further research, I think it would be very interesting to conduct interviews with representatives of the public order and safety departments of the study municipalities to ask them how and when they arrive at their decision in these particular cases. But I think my time is almost over, so I will round up now. Thank you. Thank you.
Okay, thank you very much. So, in this last 15 minutes, I would like to share with you some thoughts about emerging digital obstacles that some people, particularly people in vulnerable situations, may find in the already tortuous path to decent and adequate housing. Over the last few decades, we have been accommodating our societies to a new digital paradigm through platforms and cloud service of any kind. We can now access, for instance, to the acquisition of commodities of any kind. We can buy groceries, we can buy books, clothes, we can contract services, follow university courses, or pay a visit to the doctor. We can as well, of course, rent a room or buy a house. Everything remotely, from the comfort of our laptops and mobile phones. The growing digitalization and automation of services has, of course, important benefits. It saves costs, it speeds up procedures, and of course, it allows for more flexibility. Insofar, we are not dependent on a particular timetable or a particular location to access to goods and services. It may also, in some occasions, allow for a more efficient allocation of resources by overcoming some of the trade-offs and informational costs that exist in markets. The suppliers and demanders meet more easily than avoiding waste of resources and, as well, the underutilization of assets. Under these premises, the digital paradigm has also spread to the public sector in the last decade. Administrative procedures are being increasingly digitalized. It saves costs to the public budget while flexibilizing the rigid administrative bureaucracy. From the same mobile phone, from the same device we use to order food or buy theater tickets, we may, for instance, nowadays apply for housing allowance or any other benefit of any sort. Whenever we want, wherever we are, just by accessing to the digital portal of the administration, clicking continue, and submit. The introduction of digital procedures and the use of digital artificial intelligence to automate administrative decisions have recently reached central issues for the exercise of rights, like the access to nationality, the allocation of welfare resources, or the detection of fraud. It has been, however, also questioned by some sectors of literature who points out the potential externalities for the exercise of social rights and the protection of human dignity, especially in regard to people in vulnerable situations. Because despite its obvious benefits, digitalization comes with some drawbacks. Beneath the flexibility of the digital paradigm, there are also some perverse aspects. Digital procedures are configured in such a way that is non-attendance mode. So basically, there is no one there behind the counter. And what happens then if a technical error occurs, for instance, or if there is any unforeseen aspect that needs discretionary assessment? Regardless of our level of digital literacy, the absence of a person there to rely on during an administrative procedure may constitute itself an important obstacle in successfully interacting with the administration. This is especially more obvious, and it has a more big impact on people who lack for the resources and the necessary technical knowledge to successfully interact with the administration. Age, gender, or economic status are, among others, important factors in this regard. I would like to share with you now some data from the Digital Scoreboard Statistics of the European Commission. This first figure shows the distribution of individuals with at least basic overall digital skills among general population and across different European Union countries. As you can see in this second figure, which shows the distribution, the same distribution, but among individuals between 65 to 74 years old, the digital divide is real. and especially accrue among certain countries. While in the Netherlands, for instance, the amount of people aged 65 to 74 which has at least basic overall digital skills accounts to 60% or 50% in the case of Ireland. It doesn't even reach 30% in Germany or Spain. It barely reaches 10% in Greece, and in Poland, Bulgaria, and Romania is below the 10%. So, there is a tension between the expected gains of the digitalization from its benefits and the risk arising from its implementation. The context of this digital divide makes us to think that maybe the digitalization comes with some obstacles for people who lacks or who suffers from more problems in acquiring the necessary resources and skills to digitally interact with the administration. This phenomenon, however, is not unique to the digital context and the digital part. It is, in my opinion, deeply rooted in a broader framework of administrative vulnerability, as termed by Professor Nogueira Lopez, because albeit constitutional or legal recognition of social rights, some administrative practices and the configuration of administrative procedures might as well hamper the effective access, especially for vulnerable people, to those rights. So, for instance, residence requirements, banning people from accessing to finding newcomers, for instance, or non-residents to accessing to social housing programs, or minimum income limits or maximum income limits, budget limitations, compatibilities with other social benefits, among other questions. The digital obstacles simply add to that list. So, drawing from this conceptual framework, I wanted to conduct some empirical research on this process to determine to what extent this was present in the European context and to what extent it had an impact on the exercise of the right to housing. Within the project that the Armela Research Group is currently conducting on the Spanish process of digitalization of the public administration, and with the collaboration of Professor Nogueira, I approached this issue through a case study of the Spanish housing regulations configuring the digital part. As housing is a devolved matter in Spain, I mainly focus on 3 regions, which are representative of 3 different policy models, housing policy models, grading from a more free market approach to a more intervention. I conducted this analysis through a systematic content of analysis of the infralegal instruments concerning housing rights, both social housing regulations and subsidy calls as well. The aim of this research was to determine to what extent those procedures were imposing a non-attendance mode and to what extent those procedures were requiring special resources or skills to access to those social housing programs. Regarding the first dimension, I wanted to analyze whether the procedures were demanding the submission of applications online. I also wanted to examine whether notifications were done by electronic means and whether procedures were also providing or not for personalized supports for applicants with special needs. In regards to the second dimension, I tried to analyze whether those procedures were requiring the downloading of forms or other documents from the administration's digital portal, both in face-to-face procedures and digital procedures, whether the identification in procedure was required by means of an electronic certificate, and whether the access to digital portals were conditioned on specific software or hardware. For instance, a particular browser or a particular browser version or a concrete device, laptop, mobile phone. Briefly summarizing the results of this research, I can conclude that there is an increasing digitalization of the procedures for accessing to social housing programs in Spain. A significant boost happened after COVID-19, although previous trends can be also identified. I can tell you that in 2 of the 3 analyzed regions, this digitalization was imposed to some extent non-attendance mode, prioritizing the access through digital procedures or even imposing it when involving young people. Also, in those two of the third analyzed regions, the resources or skills necessary to access to these housing social programs were imposed highly. So, for instance, identification is necessary always through an electronic certificate in Galicia and Valencia. It's optional in Galicia and Madrid. It's optional, however, in Valencia. The requests for documents exist in both Galicia and Madrid, and albeit improved multi-platform accessibility, there are still some lack of improvement in terms of providing, for instance, specific applications or apps to facilitate the access to procedure. Interestingly, we found that those administrations had specific apps, for instance, for tax paying or for other administrative reasons. In my opinion, although this digitalization is interesting, obviously for its benefits, it can also create obstacles to the access to housing. Given the structural nature of the digital divide among certain social groups, these regulatory trends, if not combined with appropriate measures aimed at targeted groups with special necessities, may constitute a discriminatory policy which is contrary to the universal nature of the right to housing. It is true that positive obligations, programmatic obligations for the states in relation to the right to housing have been generally interpreted with a broad margin of deference. However, the establishment of mechanisms and procedures that systematically harm certain groups of people, in my opinion, are not supported under a broad interpretation of human rights. In this regard, for the case of the European Union, I believe that the joint interpretation of those programmatic obligations and the right to a good administration might be of interest at this time of increasing digitalization. The emerging shaping of digital rights in the context of the European Union cannot leave aside the idea of a just digital transition that extends as well to social rights as the right to housing. It is a matter of acknowledging the procedural administrative dimension of social rights, that some rights need the active provision of the state for their enforcement. Summing up, I don't think we need to detach ourselves from the digital society. I think it's important to advance in the simplification and rationalization of the administration and administrative procedures, and I think that the digitalization can help. However, this process, must not be articulated in such a way that harms people's rights. The current scheme being developed in some regions in Spain, for instance, may compromise the exercise of the right to housing. I think that states need to take the necessary steps for the realization of the right to housing in a proportionate way that realizes the situation of people under vulnerable conditions that lacks the necessary resources to digitally interact with administration. In my opinion, the introduction of complementary measures might be interesting in order to guarantee that everyone, regardless of their digital literacy, have access to a housing. Thank you very much.
Thanks everyone, thanks for the wonderful and very interesting presentations, and thanks of course also to the audience. Before we open up the discussion with the audience, we are first having a discussion among the presenters. If I have it correctly, the first discussion to the first presenter is Andrei, you were reacting to Roxani's presentation, right? The floor is yours.
Thank you very much. So thank you very much for your presentations, very insightful. I have the impression that the results of our research both relates to the same question, that the human rights law is not always enforced in practice. I also found a strong connection between the results of your research and my perspective, which are the administrative obstacles. Insofar, asylum seekers' law must be put in force, usually from the state, of course, So I wonder, in the first regard, whether you think that those procedures articulated both in Greece and the Netherlands, as you described, may at some point as well put an effect, disruptive effect on the rights of the right to housing of asylum seekers, whether the own configuration of the procedure has a certain impact in this regard. And besides that, I also was very curious for the configuration of the reception centers. I am not very literate in the situation of the other European states. I know the case of Spain, which is also known for those reception centers whose morphology is more than Christian-like. So I wonder as well, what's your opinion on the impact that these reception centers might have in the right to freely choose the own residence of the asylum seekers? If you have any commentaries on it. Thank you.
Thank you, Andrei, for your question. Well, if I understand well, your first, I will start from the second question, I guess. I think it was clear from my intervention that I would not be in favor of closed centers. Because I believe that it does impact, it has a very negative repercussion on the right to choose, on the right to freedom of movement, actually, not even to choose a residence. Fundamental. So, and there were many voices raised a year ago when the first center was inaugurated, at that time in Greece, saying that prison-type establishments are not in the nature of hosting and supporting people seeking for international protection. So I'm not in favor of closed centers. I would definitely not be in favor of mass accommodation camps where people are actually subjected to inadequate housing conditions. This is why I mentioned the best practice of the ISTEA, and which unfortunately was funded until 2020, 2021, I believe, and then we had another program called Ilios in Greek, which was in the same direction. Since we no longer have the funding, things become much more complicated. So I believe that the best way would be to offer alternative housing conditions for people through apartments, not through camps, through prison-like or closed access facilities. As for your first question, I'm not quite sure I understood the question itself. I believe that the main problem, I will just answer it, and if I'm really not perceiving your point, you can tell me. I believe that the main problem with the implementation of the right to housing with regard to asylum seekers and refugees could be, in some cases, even a question of political will. So, and we can see that because, as I mentioned, there are many differences between reception in member states, which is not the case as regards, for instance, asylum procedure. There, EU has actually managed to have a sort of harmonization. With regard to the reception conditions, we do not have such harmonization of situation. There has been a discussion about changing the legal instrument, because now actually making the provision contained in two directives here. So there has been a discussion about changing this legal instrument and replacing it by a recast directive, or there were even voices raised talking about directly applicable regulation for reception, which would probably remedy for the lack of harmonization, but I'm not sure whether it could be applied, all of those different conditions, reception conditions, on and to close, to wrap up, why do I believe that it's actually in some cases a will? Because it's not really that difficult in some cases. I'm not referring to the refugee crisis of 2015. I'm actually referring to different or even Greece of 2022, where we have learned actually our lessons, or to the Netherlands as well. After seeing what was the reception of the Europeans of Ukrainian refugees, we realized that people can actually benefit from reception conditions, adequate reception. And there we were wondering why, with third nationals, these reception conditions cannot be implemented. Did I answer your first question?
Yes. Thank you. Thank you.
Is there anyone from the audience that would like to respond or ask a question to Roxani about access rights of refugees? No? Okay, then we continue with Roxani's comments to Stefan's presentation.
Thanks to both of you for your very comprehensive presentation. Very thanks. I'm really looking forward to reading your third paper.
Almost finished. Almost finished.
Really. So I have a comment and a question at the same time. So I understand that excluding a person from a certain urban area is actually might be a restriction and a clear interference with one's rights. So to borrow the European Court's methodology and terminology, we would need to assess the proportionality of such a restriction. So I really find it very hard to understand how can such a measure, an exclusion, which could create a vicious circle, actually, you know, how poor home can lead to homelessness, and then unemployment, and then offending and reoffending again. So how can such a measure, an exclusion measure, can be considered proportionate to the extent that there aren't really any available data on ex-offenders? So I could think of many other measures and solutions less severe and more proportionate. Thank you very much. This would be a comment and a question.
Okay.
Can it be considered proportionate?
Thank you. Well, actually, there have been a couple of cases in the Netherlands dating pre-2016 about the area exclusion ban, so about restricting some municipality. For instance, there was one case, I think it was 2010, in which it actually was brought to court, and it was not viewed in light of the right to housing as such, whatever, but under Article 2 of the Fourth Protocol to the EC. So that's freedom of residence. And there is a proportionality test within the freedom, paragraph 2, I believe. Paragraph 4, sorry. So the court actually went into that. But the thing is, the court only went to the proportionality in terms of the size of the area and the time limit. So basically, it wasn't in time. It was unlimited. So the court said, okay, so that's not proportionate because you have to have a smaller time frame. So I just say like 3 months or so. Also, a blanket ban for the whole municipality was too large a ban. So those were the two components where the court on multiple occasions have said, Dutch courts, that such a measure is disproportionate. But it was on Article 2 of the Fourth Protocol. There haven't been many cases, as far as I'm aware of, since 2016 about this. Might, of course, be that it doesn't say, of course, that municipalities, mayors, who are responsible for this, do no longer issue such bans. Could also mean that people are less likely to go to court. That's a black box. So that would be interesting to find out, of course. But I think maybe we should talk to the ex-offenders who are actually banned, but it's hard to find them. But it's a good point. So basically, the proportionality test in itself is being conducted by Dutch courts, but on the basis of Article 2 of the Fourth Protocol.
Anyone from the audience who wants to respond or ask a specific question to Stefan about access rights of ex-offenders?
I have a question.
Yes, please go ahead.
I guess it's kind of to both like Stefan and Roxani because it's a bit of an intersection. But maybe I guess more to Roxani. But I'm curious, and I know this is probably looking at a different sort of phase of housing for asylum seekers. But do you think kind of this like concept of social unrest and integration that Stefan is looking at in terms of like placing ex-offenders in like permanent and adequate housing, is it like useful, or can there be a corollary for asylum seekers who are struggling with like integration into their new community, like when they've found some level of permanent housing? I know that's kind of a different step of housing than what you were looking at, but yeah, I don't know. I was just curious to hear your thoughts.
I think it's a very interesting idea to look into this. There have been local communities in Greece who have absolutely no reaction to refugees and asylum seekers being in an area. So I'm not quite sure if it's always about social unrest, the concept of social unrest.
In the Netherlands, it is. In the Netherlands, there's a lot of social unrest.
About asylum seekers?
Yeah.
So probably it's a good idea to look into this.
Yeah, definitely.
Perhaps the difference with the Netherlands is that or with asylum seekers in the Netherlands is that then it's about, for instance,
the camps.
The camps.
Yeah, not
so
the housing.
Not saying that in Greece were, and we're not. Most of crisis. But it would be an interesting thing to look into. Yeah.
Nice, thanks, Emma. And then last but definitely not Stefan.
No, Andrei.
Yeah. What? Yeah, Stefan to Andrei.
Yeah, last but not least. Yeah, thank you very much, also you, of course, for your very presentations. Very relevant topic, I guess. And I think just to link it with my own research, it's also a highly relevant topic for my research target group, the ex-offenders, who of course have a range of problems. But a particular one is intellectual disabilities, for instance. About 40 to 50% have intellectual disabilities. So I can imagine that for those people it's very difficult also with regard to online forms and digitalized procedures. You already showed the Netherlands is a highly digitalized country. And I know that a lot of, we as home seekers in the Netherlands know that it's very difficult to get for instance, a rental place here in any city in the Netherlands if you are not online, basically active. But anyhow, I have two questions for you. The first one, and we'll let you answer before I go to the second one. First one, talking about this target group. So firstly, digital illiteracy is something particularly see in case of certain social groups, for instance, the elderly, as you showed, but also people with limited mental capacities, such as those ex-offenders, perhaps also minority groups who are less familiar with the language those forms and procedures are written in. So would it be an argument for you to say that apart from affecting a person's housing rights in this particular context, would it perhaps also be maybe also formulated as a discriminative practice to solely have digitalized forms, digitalized procedures? So is that, I'm interested in your views about that.
If the mere fact of having just digital forms is a form of discrimination itself.
Yeah.
First of all, I would like to thank that you brought your research into it, because I haven't seen an intersection before, but indeed, while people is serving time in prison, they are usually in most of the countries away from computers, and we know how quickly technology evolves. So it's probable that a person, an ex-offender after exiting prison, might find increasing difficulties in engaging with it. And yes, coming to your question, I think it's discriminatory practice itself, but I think it might be proportionate as whether it's imposed, if it's imposed under certain conditions and for certain people we know they can afford for the resources and the technical knowledge. As in the research, in my research, I found that, for instance, in Malaysia, the access to social housing programs for housing allowances for people under 36 years old was imposed as mandatory. It was obligatory for every people who is below 36 years old. I don't think that is proportionate or justified. I can understand that, as we know, for instance, that education is related to digital literacy, and we have data about that. We know that high education levels are related to higher levels of digital literacy. Maybe imposing, for instance, in universities, backgrounds or frameworks might be proportionate and justified. But general obligations, I don't think it's proportionate to this.
Okay, thank you. Yeah, so my second question is because you had something on the slide about your 3 case studies, and Valencia, if I remember correctly, was the only one with personalized support. And I was wondering, would you say that kind of, I don't know exactly how that personal support looks like, but would you say that would count as a sort of best practice for other organizations or other areas? So, for instance, it was just in the news, I think, recently in the Netherlands that we now have, I think it's for free as well. I don't know if the Valencia support is for free. Assistants located in public libraries, for instance, who help people who cannot understand digital forms and stuff like that. So you can just go to the public library and get that support. So, basically, I have an A and B question. So, A, how was the personal support organized in Valencia? And B, would that be a best practice for other areas?
Answering your your B part of the question, indeed, I think it's a best practice. I think it's the best way to advance in the simplification of administrative procedures. How it works, they have 2 scheme systems. So, for people who is in particularly vulnerable situations, economic particular situations, for instance, social services are in charge of submitting everything. So any due documents and anything is provided by social services. So people have always someone to rely on, and they don't have to face with the struggle of digital apparatus. The other scheme is for the rest of procedures, for the general population with less with more advantageous situations that face these digital procedures. It consists mostly in what you explained about the case here. Assistance in libraries is mandatory to provide this kind of assistance in a network of offices. So you can go there and ask for instruction or ask for information about you are not provided the whole procedure, but you can have some.
And that's for free then?
Yes.
Because otherwise, okay.
Yeah, but it's only related to administrative procedure. So it doesn't apply, for instance, if you are looking for a house in the private market for.
Okay.
Yes. I don't know if here it also applies for that, because that would be very interesting.
Yeah, no, I don't think they have it for housing, for housing assistance, but just for like social welfare. Yeah. Thank you.
I have a question because I was really triggered by what you mentioned about what should the role of the government be in this, and of course the human rights, and thus also the right to housing. That's the role of the government to protect those human rights. This week in the university newspaper was a case about Xior student housing. That Xior is an enormous building here at the campus. We have a university campus here in Groningen. It's called Zernike, and they recently built a new flat student housing with a lot of apartments. And what the landlord of the student housing does is they, at every first of the month, they open new rooms for students, make it available, but they also sometimes make rooms available throughout the month. and there's a person, or maybe multiple persons, but at least one person who created software that automatically fills in the forms as soon as a room becomes available. So a human, a student looking for a house, is no longer able to fill in those forms because that software already passed the line, skipped the line, immediately filled out the form, gets a pop-up, and everything is done. So there's now a middleman that basically collects money from students. So students need to pay around 400 to 500 euros to the middleman. And the middleman has this software and makes sure, okay, I can make sure that you get a room next month because my software automatically fills in the form. Now you're first, because it's first in, first comes, first serves. And so the student that pays the 300-400 euros to that middleman, and the middleman makes sure throughout the software that the next available room is for that particular student, which of course has a lot of tensions with discrimination, digitalization, and access rights to a house. What do you think that the government, because now it's known to the municipality also responded in this article in the university newspaper that they are aware of this problem and they are looking into it. The landlord is now aware of this problem, of course, mentions that that's not the idea of this, the way they proceed and give the housing. But what do you think that the role of the government should be in such cases where AI basically hampers the availability of housing because of the digitalization?
So this service is provided by a public administration? Or
no, so this is just a random person created software.
No, but the procedure that...
yeah, so the online application form is from a private landlord. It's not.
Landlord.
Yeah.
Yeah, I think there is an important gap because, of course, we know the role of the public administrations in regard to administrative procedures. I think that states might monitor the behavior of market, but I don't know to what extent they can do something there. I don't know if it's a discriminatory practice itself, since it comes from a private landlord, right? Because I don't think it's itself a discriminatory practice, but for sure the public administrations should monitor the behavior of markets, and particularly I think they have some obligations in regards to big actors in markets, those who act as from a monopolist position. I don't know which is the case in this particular sense, because we are dealing here with basic human rights, which is human dignity, because housing is necessary for the development of personality and many other things. So yeah, I don't know exactly. I think it's a very good thing to where those obligations, which are the limits of those obligations, to what extent something can be done from the public administration in regard to those kind of practices.
Anyone else with a question for one of our speakers? Do you want to react to each other?
Yeah, probably until we have another question. A brief comment, because I had an experience actually, something which relates to both of your work. I had.
Are you interested now? Intrigued.
Yeah. I had students, prisoners in the Hellenic Open University, who both were not familiar with how to access. And secondly, they were not granted access to computer. I think unless for twice a week, half an hour, so 1 hour per week. So that's all they could do. And I had several students actually who were mainly in the safety prisons in Athens. And what they did, there was an association of volunteers, and but those people were volunteers, who offered to do the job for them, and do the job and access the information we would send them. They would print out every document, and they would help them actually understand the material we would study. And all they had to do, our students, prisoners, was only attend classes, which at least the prison authorities would allow them to do. So it was an interesting idea to bring those people in. It could be institutionalized though, or give them more hours to.
Yeah, definitely.
It would be easier. Yeah, that's all I need to share.
Anyone else before we wrap up? Who wants to? Oh, and the light suddenly turns on again. Who has a question for one of the speakers? No? Then I would like to wrap up this session. Thanks everyone, but especially thanks to the speakers for our first hybrid seminar, at least in this series of multiple seminars. The next one will probably be in February. That will be a individual talk again with just one speaker. And then in May or April, we'll have the second hybrid seminar on in-housing rights. And we hope to see you there. Thanks a lot and see you at the next EVICT talk.